Hello, Justice Bryar. It was truly a thoughtful presentation, and I bet you know that you were talking Justice Marshall and President Jackson, and our thoughts were roaming to another justice and another political leader. We'll talk about the US constitutional law, but I have to ask you, I bet you're up to speed. I don't know if the audience here is aware of what's going on in this country for the last half year, but I bet you are well aware. And so I just want to ask you, as far as your thoughts and your feeling go, are you worried for the fate of Israeli democracy? You have the mic here.
What I think inside my head?
And in your heart.
And in my heart?
Mm-hmm.
That's who they're going to say. I'm not an Israeli. I'm an American. And the problems of a different country have to be worked out by that country. And if they find some solace, instruction, or information in the difficulties that it's taken America, the United States, to create a society that we hope will have a rule of law and continue to have it, that's for you to work out.
For us
and
to...
I'm not representing the government of the United States, and they're busy at work. and so, therefore, I've given you a long excuse, which I'm very good at, and why I will not answer your question directly. and there we are. What I think is a matter for me. And his question is, what do you think? And did you find something? What else can I add to that?
No, it's okay. It's okay. Let's go to your own constitutional law. But I have to tell you that one thing that the architects and the supporters of this judicial overhaul keep hammering is, look at the US, the greatest democracy on earth. They have politicians selecting, nominating, and confirming their judges. Do you recommend this home recipe?
For another country, it's up to that country. But I will tell you, if you're the one who thinks that works perfectly, you're the first person I've met in 5 months that think that. I mean, countries have many. This is a big document. It's a few pages, it's a few words, but it covers a lot. And there are what's in it. I mean, I usually, if I want to summarize it, I say it establishes the basic rules for underlying democratic thinking. It's a boundary setting device. The Constitution is. I used to listen to that program. Some of you may have listened to it when I was 8 years old. I'd run home from school to listen to what's his name, Sergeant Preston of the Yukon, and he was in the Canadian Border Police. And life at the on the border in Canada, it was rough. It was cold. It was freezing. That border, and I said, he had a tough job. And I said, was abortion inside the border or outside the border? That's tough. But what this document does is it sets up certain preconditions for democracy. It has separation of powers, both vertically, states, federal government. So I say to the students, you want to affect your neighbors, go back to your state. That's where the law is made. And that's only a slight exaggeration. Separation of powers. And horizontally, executive, legislative, judicial. All right? And it protects basic human rights. And it assures a degree of equality. And it provides for a rule of law. But those are boundaries. And within those boundaries, you, Mr. Student, and I say to you, Mr. Student, because it's going to be up to you to figure out how to get out of these messes that sometimes we get ourselves into. It's going to be up to you. And I say, you're the ones, for a country like the United States, 330 million people, every race, every religion, every point of view. My mother used to say that. She used to say, there's no view so crazy that there isn't somebody in this country who doesn't hold it. And she said, because we were from San Francisco, she said, most of them live in Los Angeles, she said. but nonetheless, it has, I'll tell you something else we did. I mean, if you're into memories of the month, my wife told our grandchildren, if you memorize Abraham Lincoln's Gettysburg Address, I will give you $20. And 4 of them did. Why? Because he starts out that address and he says 77 years ago. And first thing he asks them, see if they read it, what happened 77 years ago? You think the Constitution was written? No. He stayed away from the Constitution because it doesn't say equality, or it didn't at that time. He went back to the Declaration of Independence, all men are created equal. 77 years ago, our fathers set forth upon this continent a new nation, based in liberty and dedicated to the proposition that all men are created equal, and we are now fighting a great war to see if that nation, or any nation, so conceived and so dedicated. Again, look, you see the point? The point is it's an experiment. And I found letters from George Washington saying the same thing. And I say to the students, you see, it's an experiment of which you are now in charge. And that experiment was noticed, that it was an experiment by George Washington, by Abraham Lincoln, and we fought wars to see that we could succeed with that experiment, and no one knows. No one knows what that future will we keep it or will we not? And that are sort of, you want universal principles? That's the best I can do.
I guess you get the $20.
No, because those are only the first 2 lines, and I fall apart after that, and I'm not even certain.
And also, I think we get the answer saying, if you guys in another country want to take any kind of lesson from the US, it's not just one facet of our system, it's the whole system.
Yeah, I'll just summarize a small part of it.
And Professor Rosnay mentioned that today, August 3rd, 1994, exactly 29 years ago, you assented to the Supreme Court of the United States, and you've seen it changing throughout your almost 3 decades on the bench. And it was, I think, 1 week before you retired that the Dobbs decision was published. Well, most of it was published a bit earlier, but we don't have to go into that. And it was, I guess, marking the peak of the ideological shift within the court, revoking women's constitutional right to have an abortion. And here's what you wrote in a heartbroken dissent opinion. This is what you wrote. After today, young women will come of age with fewer rights than their mothers and grandmothers had. The majority's refusal even to consider the life-altering consequences of reversing Roe and Casey is a stunning indictment of its decision. Were you surprised they went so far?
I was. Yeah.
And did you tell them that much?
Oh, we have conferences once a week after we hear the oral argument. We sit around the table like putting those 2 together. And the way the conference works is, and it always has worked this way, the Chief Justice goes to the first case and he summarizes and he says, my view, tentative, these are all tentative views, is that we should do this or that or the other thing for. And then it goes to Justice Thomas. And recently, it then went to me and Alito and Sotomayor and Kagan and Gorsuch. And by
then it was already clear to you, when you were in the conference room, that Roe is going to be unraveled?
Well, I recognize that people were starting that out, some of them in a tentative mode, because it is tentative there. Because after one good rule, really good, at the Supreme Court, which I hope stays forever, is no one in that conference speaks twice until everyone has spoken once. So, and we each have a book where we write down what they each say on each case. So we remember it. If we have to write the decision, I better know what you want, and, if you're on the court. And then there's some back and forth. And what's that back and forth like? That back and forth works, in my opinion. Nino Scalia thought it never worked. I think it does work. Not always, but sometimes. And you listen to the other person. You listen, and you don't say, ha, 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 I have a better argument than you. If you have that attitude, direct or indirect, they'll know that. And they'll say, ha, 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 I have a better argument than you, and that will get us nowhere. What you do is you listen to what they say and see if you can make some progress. And you can't always, but Sometimes you do. And you never, no insults, not even as jokes. It's professional, even in a case like that.
And in a case like that,
I'll say exactly what I think.
and then you clearly acknowledged, Justice Breier, the divisiveness of this issue within the American society.
Yes.
You wrote it back in the Stenberg case in 2000, millions of Americans believe that life begins at conception and consequently that an abortion is akin to causing the death of an innocent child. And others believe in the woman's right to choose. But can you genuinely frame the question as a constitutional rather than ideological or political one?
Yes.
How come?
Because you say the job of the Constitution and the laws made thereunder is to allow these 330 million people to live together in conditions where prosperity is possible and peace is even more than possible among them. So it isn't the job of the law to say between those two views who's right. What it is the job is to say what kind of rule do we have at the boundaries for a country where there are millions of people who believe these opposite things. And is that impossible to do? No, I don't think it's impossible to do. In fact, in my view, Roe v. Wade and Casey did do that. I thought that was the right view to have legally in a country where you have people who believe both. Because people don't have to have an abortion.
But the balance is stricken, Justice Breyer, the balance is stricken strictly by the interpretation of the Constitution or by the ideological backload with which the justice comes to the bench?
This is where our professions have opposite instincts. Because indeed, you want to put something like, it's a very hard question to answer. Who knows when you get something that is really important from your point of view for the human beings who have to live under the interpretation of the law? Who knows the extent to which your background affects you? And what I think is, one, why, when I got to the Supreme Court, do I find people disagreeing with me so much? I mean, in Boston, at the Court of Appeals, we usually reached agreement. San Francisco, where I came from, Boston, Massachusetts, what was this disagreement? I, who am so often so nice about the whole thing and really reason it pretty well. Why? And after a while, I began to think this. And I think it was a more mature thought. This is a big country. There are 330 million people here. They do think very opposite and different things on a lot of questions. And it isn't such a terrible thing to have a Supreme Court where there are different people who really come from different backgrounds. Because if you say it's politics that affects, I say no, it isn't. That isn't what I've seen. I haven't seen it. But if you say that a person's judgment on such things can be affected by his life, I went to Lowell High School, a state school in San Francisco. I went to Stanford. I've lived the life I've led. And indeed, by the time we're 40 or 50 or 60 anyway, we have reached a few vague jurisprudential, if you're a judge, general conclusions, and you won't just follow them rigorously, but to say you're affected or not affected by who you are in your professional life, I think is wrong. I think I got my answer, specifically when you said who knows. And you also said you don't insult each other in the conference room. No, people get on well.
But you did use some harsh words in the Dobbs decision. When you said either the mass of the majority's opinion is hypocrisy or additional constitutional rights are under threat. Do you truly believe
I usually try to write an opinion where I strongly disagree without any words that others will think are disagreeable who don't agree with me. I usually do. So the sentence you have read, which comes from an opinion that three of us wrote together, that sentence is unusual for me. And so if people follow the different kinds of things I write and how I do it, and I can't expect them to follow it, but if they do, they'd see that was rather unusual. So I must have felt fairly strong.
And you truly believe that the majority is not done with its work and other constitutional threats are under threat?
We don't know. We don't know. Time matters on the Supreme Court. Justice Douglas used to say it takes 5 years before you really are familiar with the institution. David Souter, 3 years. He was more optimistic. But you get there, and everybody would like to be appointed, or the lawyers or the judges, they'd like to be, and suddenly you're appointed. How did this happen? You know in your heart there were several other people, and you're almost prepared to say they might even have been better or at least as good. And there you are. There you are in this building. And where Brown was decided, and you walk and say, can I really do this? And then after a few years, when you get to know it better, you think, I can do my best. And that's the excitement of the job. It is, and that's as you get older. The virtue, there are virtues of other positions, and there are virtues. But for a judge, and for a federal judge who's there a long time, it's that you have to do your best in every case. You can't let up. And so that's a virtue. That is a privilege. And you better do it. And it's all easy to say. But like you say, what I think most difficult case that I read, it had to do with, I think it was called Oracle versus Google.
Okay.
Yeah, Oracle versus Google. And I and my colleagues, and it got assigned to me, have to figure out, how do you speak the Java language? What? I thought to learn that you had to move to Indonesia. But I mean, my goodness, all right. But it took 2 years to write that decision. And when some of the people who actually knew it said, well, he seems to know it, I thought, my God, how did we ever do that? I wore 2 law clerks out. I mean, it was a tough decision, and I think it matters. I think it matters. So there are all kinds of decisions. It isn't just the Dobbs of the world that are going to matter, though Dobbs, of course, will.
So you have seen this supermajority in the court being cemented throughout your years on the bench. And I wonder, Justice Bryar, what would you tell someone who'd wonder if it just so happens that the court was very specifically split in the Gore-Bush decision that you mentioned? All 5 Republican appointees.
There were more. No, there were 2 other Republican appointees, 5 out of 7.
And right, and they right.
And
all
the
all the Republican appointees sided with Bush.
No.
And they didn't?
No, 5 did. And 2 sided with what? Yes.
All those who sided with Bush
were appointed by Republicans. That's correct. But 2 who were appointed by Republicans were in dissent. John Stevens and David Souter and me and Ruth. Those were the dissenters.
And you didn't feel that this was a decision in which the political split within the court was so transparent?
This is a tough thing. Maybe if I only had you as, if I only could get you to have written this, it would be helpful for me. I tried to write in a lecture. It's not politics. That's the wrong word. I worked for Senator Kennedy, part of my career, and politics was, if the mayor of Worcester is on the phone and the Secretary of Defense and Senator Kennedy has to answer one of those calls first, I know who he's going to answer first. And it isn't the Secretary of Defense. That's where the votes are. I mean, when you're working in the Senate or the House, there's a young lady who was in my office reading all my memos. So I said, excuse me, can I help you? What are you doing? And she said, oh, I'm a student and I wanted to see how things worked here, so I just came in your office and there was nobody here and there were some papers on the desk that I read. Did I get angry? For a second. But I thought, hey, maybe she's a constituent. And that is politics. Are you a Democrat, a Republican?
So you say you know politics when you see it, and
well, I mean, I know what my experience
you haven't
was
seen
in the
politics,
Senate,
but I want.
That's not what it is.
I think it's important for the audience here to listen to what Vice President Gore said of that decision of the court in which he dissented. He said, and it's so important to listen to it in Israel these days, I strongly disagreed with the Supreme Court decision and the way in which they interpreted and applied the law. But I respect the rule of law. So it is what it is. It is what it is. Now let's talk, Justice Breier, unconstitutional constitutional amendments.
Wait. Because I want you to know two things.
Go ahead.
And he added to that, don't trash the court. And the same words, just about, were said by the younger President Bush when we decided a few things that he didn't like. And he said, I don't like the Supreme Court decisions about Guantanamo, I think. I don't like those decisions. I think they're wrong legally, but I will follow them.
And we are living this reality nowadays, and that's why I want to ask you, Justice Breier, about the notion, the theoretical concept of unconstitutional constitutional amendments. It's an intricate and complicated and lengthy process to amend the US Constitution, therefore it happened only 27 times. But in theory, can the court intervene in a constitutional amendment?
I have no idea.
If the constitutional...
Now you begin to see but the
no,
job
but
is...
I'll give you an example. If the Constitution is amended in a way in which the First Amendment is cancelled, is over and done
Article
with.
7 says how it should be amended.
And if it's amended
properly...
properly...
And if it's amended contrary to Article 7, maybe you'd have to have the specific case, maybe the court would intervene. I don't know. And that is the difference between when I used to be a teacher and when I am a judge. I mean, when I am a judge, I have cases in front of me, and I have enough to do to decide those cases. And so I say, I heard Rehnquist say this once. It was great. He wrote good opinions, Rehnquist, and he put in a decision. I said something that nobody could understand. I said, why did you put this in? And he said, because first it'll bring us together, and we'll get a majority. And he said, I know it's a little obscure. He said, but let the law professors figure it out. That's their job. Okay, so that's sort of what it's like. I'm trying to give you a little picture. I mean, this case, I have to worry about this case, deciding it correctly, and deciding how I'm going to get a majority once I think it is correct, and that's the heart of that job.
I guess what I'm asking boils down to the question, are judges, in your view, better guardians than politicians of the core values of a society?
You can ask yourself that. We have a lot of experience in the world. I mean, what do you want? Core values? Core values in a democracy based on human rights and a degree of equality and a separation of powers so nobody gets too powerful, and a rule of law. Put those into your head and say the politics for Mr. Smith and Mr. Jones runs the other way. You can answer that question. But what Madison thought is what Madison and the others thought is, why should we give the court? And Marshall basically says this, John Marshall. Why? He said 78. It's in Federalist 78. He says, somebody has to have we've written this beautiful document. This is a really nice document. That's my passport. It's not so but here, great document. This is beautiful. Hey, but maybe people won't follow it in the Congress or where they have power or in the courts of the president. And if there is no one who has the power to say when someone has gone too far and isn't keeping to those basic values, let's put it in the museum. Well, hang it up in the Smithsonian. No, he didn't say that because the Smithsonian wasn't there then. But nonetheless, this will be a document of beauty but of no practical value. So somebody should have the power in order to say when the others have gone too far outside those boundaries. And he said, should it be the president? No. Why not? Well, he'll just say everything he did is right. You see? So that's like not having a power. What about Congress? And there he says, basically, read 78. He says, Congress, there's a lot to be said for that, because it is a democratically elected institution. But I'll tell you one problem. They want to be popular, don't they? Not always, but much of the time. And boy, do they know popular. They know it. They understand it. Not always, not everybody, but by and large. But this document that we've written is designed to give the least popular person in the United States, and you can have a contest, who is that now, I don't know, but the least popular person in the United States should have exactly the same rights under this document as the most popular. So it's a little risky to give this job to people who put so much weight, so much of the time, on popularity. Well, what about the judges? He says, well, the judges, if you read it, the judges are not that great. They make mistakes, but one good thing is few people have heard of them. Another good thing is that they don't have the power of the purse.
Or the wallet.
Or the sword.
Or the sword.
Or the sword. And so they'll have to, if you go back to Cicero, he says, the way a leader gets power and has people do what he says Cicero, is only three ways. One way is pay them. The second way is threaten them. And the third way is do your job honestly. And that third way sometimes works. He said, the judges do know law. And this document has something to do with law. He's not 100% enthusiastic. It's interesting to read. But they know something about law, no power of the purse, no power of the sword, so they won't be too dangerous. And so they're the ones who should have the last word most of the time. And that's picked up by John Marshall in Marbury versus Madison.
Without a purse or a sword. Justice Bryar, can I ask you a personal question?
Of course.
What made you retire?
What made me retire? I thought, well, I'm finding a little harder time agreeing with everybody. I think my dissents are marvelous, but I don't think they're that marvelous. Do I want to spend a long time? And I'm 84 years old. And you can't last forever. And there we are. So would I rather go, which I've done now, the more powerful thing than the politics is the jurisprudential theory that some of the people share on the Supreme Court, which I do not share. And so I thought a better use of my time will be to go back to teaching and write a book.
And did you also consider the fact that if
you could get it if they publish it.
And did you also consider the fact that if you don't retire on time, the liberal minority in the court might become even smaller?
Hard to say. It's a personal decision like that. I mean, I have a lot of experience, as do you, in deciding things that aren't personal. You start getting your own personality involved. Oh God, what a mess! So that's hard to answer. Would it be even smaller? We don't know.
But I'm asking if it crossed your mind.
Of course, it would be there. It would be there in my mind. But I'd have to answer it if I'm answering it honestly. We don't know.
Right.
And that's what. Who am I thinking of? I was thinking of Harold Macmillan. He says history is just one thing after another.
Ruth Bader Ginsburg. You know, Justice Breyer, you've written 551 opinions in your 28 years.
Did you count those opinions?
I counted every one of them. In your 28 years in the court, and you spent probably thousands of hours on the bench and in the justices' famous conference room. And I want to try and picture with you and with the audience a scenario. Mm-hmm. They sit there, the justices, perhaps in the US, perhaps in some other place. They discuss, for instance, the constitutionality of a piece of legislation. It's noisy out the window. They know that the statute is part of a scheme. Can they truly ignore what happened before, what government might do afterwards?
No.
Can they truly focus only on that piece of legislation?
But why do you make that distinction? Don't you think what they did, what happened before with the legislation will have something to tell us in many cases about what this legislation is about? If there was a huge argument about A versus B, and this legislation seems as if it might be addressed to that argument, wouldn't it be helpful to know what that argument is? And as far as what they would do later is up to them. But even in some instances, you want a rare instance? All right, this is rare, but I'd say this is one of the unusual situations where it was political, where Frankfurter said in the conference where they had a miscegenation case, interracial marriage, forbidden in Virginia. Shall we take this case and say it's unconstitutional? Frankfurter said no.
Which was risky at the time.
Yeah, and he said, no, don't do it. We're having enough trouble getting them to integrate the schools. That isn't happening yet. Let's do it later. And they did it later
And what do
in
you
Loving
think of
versus
that?
Virginia.
And what do you think of a court realizing the right legal outcome is A, but it's too risky to go there?
Too risky, boy, that's a dangerous path. But you never say never. I mean, that's just be careful. And you say, go back and read, you were talking about Cardozo, Ron. And I read, he wrote a pretty good book about being a judge, and so did Holmes, and so did Brandeis. And that's so true. You say, first of all, there are many different things you look at interpreting a law. And you've mentioned a few of them. But of course you read the words. If it says fish, that isn't a carrot, okay? And you can't make a carrot into a fish. But most of it is more obscure than that. All right, so you look at the text, you look at the history, you look at the objectives or purposes of the statute, and consequences too.
Consequences to the court itself sometimes.
Yeah. The consequences of the court, be careful. Be careful. Because what do I want? Which I probably can't achieve, but boy, if I said the one thing that I want in appointment of a judge is character, a decent character, and don't think about yourself too much. And when I think that, and occasionally I do, I think of what Ken Galbraith said when he came back to Harvard after Jack Kennedy appointed him ambassador to India. And he was walking across the yard, and an economics colleague of his came out and said, "Oh, Ken, God, you're back from India." "Yep." He says, "That must have been fascinating." Galbraith said, "Yes, it was. It was so fascinating. I found that I didn't think about myself for seconds at a time."
But that's a politician. You know, Justice Bryar, we're honored to have Chief Justice Barak with us here today. And I know you've read many of his and his colleagues' opinions, and you've cited some of them. And you know Justice Barak is perhaps the person most identified with our court's endeavor to create here a Zionist, Jewish, liberal democracy. And you said 20 years ago on Justice Barak, he has had to implement that kind of system. What did you mean by that?
I meant that we all, and you see it now all over the place, we all have certain objectives and we have certain problems. We want our governments to work in ways that will treat people respectfully, that will in fact treat them equally in terms of the law, that will in fact bring greater prosperity, if possible, or help, and a more peaceful, less disputatious societies. And when I say we, I can look across the world. I can look across the world. And if you say go back to Diana, fine. Go back to the prophets, fine. Go back to the Magna Carta, fine. Go back to the Constitution, fine. We're trying to achieve those objectives, and they're pretty hard to maintain in a world which has increasing populations, people moving across boundaries, concerns about the environment, concerns about how to maintain the democracies that we have, concerns about, and we can have disagreement after disagreement. So that's It's so easy for me when I talk to Stanford students, or I just say, I'm sorry, my friends. Hey, that's your problem. It was mine. It is. And I say, but they want something more than that. And I say, the thing I learned the most in my life, I think, about how to act in public was from Senator Kennedy. He was a very, very good senator and got lots accomplished. And what he told his staff, me and many others, he said, when you're having trouble getting a point across, or getting a law passed, or stopping some other law, getting an amendment, and John Stuart Mill said this, he says, here's what you do. Find somebody who really disagrees with you, and sit down and talk to them. And when you talk to them, don't do all the talking. Get them to talk. And if they talk, and I saw it happening, it works. Not always, sometimes. When they start to talk, if they talk long enough, you will find something you agree with. And when that happens, you say, that's a very good idea. Let's see if we can't work with that. And you're serious about it. You're not being phony. And if you work with that, and then something emerges, and it's 40% of what you wanted, take it. Do not reject it on the ground that all your normal supporters will think you're a hero. Take the 40% you can get. And then, when the press conference comes, and I saw him do this so often, and you get up, if you're there. It'd be nice if you were. You get up, and you say, Senator Kennedy, you did a good job. He says, don't thank me. Thank Senator Hatch. He said, credit is a weapon. Credit is not something to try to grab. Credit is a weapon you use to help bring other people along. And remember that. And because he said, I'll tell you, if you get something that works fairly well, there'll be plenty of credit to go around. And if it doesn't work, who wants the credit? And I mean, that was that world I worked in, luckily for me, for about 3 or 4 years.
We could spend hours talking about how to forge a coalition within the Supreme Court, but I want to step back just for a second before we have to wrap up this conversation. Yeah. Is it possible, Justice Bryar, that all the things that worry you about the rulings of the Supreme Court recently, concerning abortion, concerning affirmative action, concerning gay rights, concerning other human rights that you care so much about, can it be a backlash that has to do with the fact that a large part of the public within the American society did not see themselves in the court for years?
It's possible. I mean, I used to say that to Nino Scalia.
Used to say?
To Nino Scalia, I'd say, a lot of what you're saying, you don't like what Justice Brennan decided. Mm-hmm. And I tell you something, I am not Justice Brennan. So why are you taking it out on me? That's just it. And so it's possible, yeah.
And when Justice Kagan said recently that some new judges come and toss everything outside, is that what you feel as well?
They're not going to toss everything outside. I mean, my goodness, the room for them, you can be, I mean, they're judges, and people are more conservative judges than some other people in their views of law. All right. But, it's many, many decades. And law is this, I used to think of it, and that's what Holmes says at the beginning. He says, when you're interpreting a new law, he says, my God, you're acting against a backlash or a backstock, or what do you call it, a stockpile? Set up to the ceiling. And the room, I used to think of being a judge as there's this huge mass of a mess. Don't say I said that. The mess is the law. You see, and suddenly you come in and there's a question and you try to put a little bit of enlightenment here, make it a little bit more logical, make it a little bit more helpful, etc. Do you look to consequences? Yes, of course. We had a case involving the consequence was going to be really wrecking the medical part of the medical system. I said, of course you look to that. You don't look to the language entirely. The language allows this. Of course, you look to a number of things. What do you look to? There isn't a definite rule. Well, where did you decide to look to over here to history, and over here to consequence more, and over here to the reasonable legislator who's a fiction, but nonetheless a useful fiction? And where do you get? How do you decide? And Holmes says, that's why you're a judge. You have experience. Well, it's your experience.
Is a touchy word these days in Israel. And I know you're so cautious when it comes to giving advices, and yet I'll try it one last time. There's a lady, as we speak, a lady sitting now on the bench in the Supreme Court, exactly in the same chair in which Chief Justice Barak sat and Chief Justice Beinish sat, and their name is Esther Hayut. And what if she would ask you, Justice Breier, I can be cautious, I can be valiant. What would you tell her?
I would tell her that she's the judge, but it's more than that. It's more than that. I mean, I've written, one of the things I wrote about is why we, the Supreme Court of the United States, ought, in instances that are relevant, look to what courts in other countries do. Look at their whole system if you're going to see what it is. And when you read it, because today many countries have constitutions rather like ours, many countries have systems rather like ours, many countries have problems rather like ours, and many countries give judges authority somewhat like ours, sometimes somewhat different. So read what they say. But you don't have to agree with it. You're just learning from them. And that doesn't mean you have to follow what they say. You don't. You don't. Because you start with this instinct, which helps you decide where to look, what tools to use. And then you take the tools and you use them. But they don't dictate a result. Because at the end, you're still going to have to decide, where do I put more weight? Where do I put less weight? Where do I do this? Where do I do? And that, again, is a question of experience and instinct. And when you said that one of the answers to my questions that I just gave you was really, I don't know, that was a good answer. That was a good answer. And it is, you have the same problem. You're giving your if you're not writing an article, you have to plan your show. You have to plan, which do I highlight? And what do I say? And who do I have over here that will help me?
But I don't have a prime minister who threatens perhaps not to comply by my rulings. I don't have ministers in government threatening to go and, pass a legislation which overrides the court. Should that be something that deters the court? That the court can say, okay, let's wait a minute.
No, I remember what John Marshall said about Andrew Jackson when he said John Marshall has made his decision, now let him enforce it. Yeah, when he heard that, he said, I'm awfully worried for the court. That's what he said about the Cherokee Indian case. And then over time, it became clear to people who said that this means that South Carolina is not going to pay the federal government the money they owe them, and they're going to cause all kinds of problems elsewhere, and nature took its course.
Be patient. Justice Breier, just one last question. Was there a moment throughout your career, 40 years as a judge, a moment, an instance, a case in which you knew, you felt within yourself, this is why I became a judge?
Probably the problem is that some of those were dissents. I mean,
better yet,
I don't know. I wrote I usually try to keep my writing to about 15, 20 pages. But that doesn't count the 42 pages I wrote about the death penalty. So I thought, well, I didn't have a majority. And I thought, well, this is just a waste of time. No, it isn't. Because at least if you write well and you put your heart into it, and it's not just bleeding emotion, it's logic and thought and explanation, and it gives you the chance to do that. Somebody will read it, and you never know. like I've been emphasizing probably this afternoon, the need, if you're going to make, if you, I was going to say, if a country is going to make major changes, slow, try and broad, try, etc. And I mean broad in terms of getting support, etc. Now you have to decide whether that's applicable. I can just tell you that not being any official representative, I have found that kind of thing applicable in the United States of America.
To take your time. You know, it's a well-known story, but ever more relevant. It happened on the last day of the Constitutional Convention in Philadelphia. A lady asked Dr. Benjamin Franklin, "Well, doctor, what have we got, a republic or a monarchy?" "A republic," replied the doctor, "if you can keep it." Perhaps our own Benjamin will care to remember that line as well. Justice Bryar, thank you so much for being with us. Thank you.
Justice Bryar, Ilana, Diane, thank you so much. Thank you very much, everyone, for coming and join us in our future events. Toda.